Luigi, now that you've been stuck inside for a while, you always talk about how you never watch TV, but have you finally watched a TV show? And by the way, watching the news doesn't count.
Actually, yes, I admit I watched two. One series is The Loudest Voice. It's the history of Fox News with Russell Crowe in the role of Roger Ailes. It's absolutely fantastic. It's both very well acted and super interesting. And then I watch a different series. It's called The Mechanism. It's a Brazilian series about the Lava Jato investigation.
Oh, cool.
The acting is not at the same level, so completely different cup of tea, but is very well done. And actually, it might lead naturally to discuss today's episode because Lava Jato is about corruption in major companies in Brazil and how much the Brazilian government is involved in the corruption or involved in preventing the prosecutors to do their jobs and so on and so forth. In America, we think this happens only in developing countries, that America is pure and the US Attorney General is superior human being. What we're going to discuss today is not as shiny as it looks.
Well, maybe one of the reasons that Americans have more faith in our justice system is that we don't really get to see the inner workings of how corporations pull the levers of influence every day. But thanks to an excellent piece by ProPublica, we've gotten the inside scoop on how Walmart has been fighting regulators to avoid being indicted for its role in the opioid crisis. And so that's what we're going to be talking about on today's episode.
This week, the U.S. Attorney General for Texas, Joe Brown, resigned, did not mention Walmart in his resignation, but in the letter, there was a pretty clear statement that said, we must win the fight against opioids abuse in order to save our country. But in order to be effective, we must be willing to prosecute all facets of the expansive network that feeds these destructive drugs into our community. Players, both big and small, must meet equal justice under the law.
From Georgetown University, this is Kate Waldock.
And from the University of Chicago, this is Luigi Zingales.
You're listening to Capitalism, a podcast about what's working in capitalism today.
And most importantly, what isn't.
The backdrop of this case has to do with the opioid crisis. And we've talked about the opioid crisis before on this podcast. When we covered it, we were mostly focusing on the role of the pharmaceutical companies and the doctors. We touched on, but didn't spend too much time talking about pharmacies themselves. But if you think about it, pharmacies who provide prescription drugs, right, they're the ones who distribute the drugs, they have a duty to their customers to fill prescriptions in a responsible way. And they're also bound by certain laws to make sure that they are not being irresponsible in the drugs that they dispense.
So what is very important in understanding this case, as pointed out by the ProPublica article, Walmart had signed several years ago a memorandum of agreement with the DEA because it had been accused of wrongdoing in the distribution of opioids and other prescription drugs. As a result, they reached a settlement in which they promised to improve their controls over the abuse of opioid prescription. So that's a background in which this is taking place. The case starts in late 2016 and is related to two doctors, Diamond and Wade. They both have been convicted, one for 10 years in prison and the other for 20 years in prison, for over-prescribing opioids. Question is to what extent the Walmart compliance system was able and willing to block people like Diamond and Wade, and eventually Walmart blocked Diamond in March 2017, but after the federal investigation has started. In the meantime, he prescribed 13,000 controlled substance prescription for an average of 11 a day.
So you might be thinking, how does Walmart have any blame in this? This guy Diamond, this doctor, was the one who's writing these prescriptions, and Walmart was just, listening to the doctor. But if you're a pharmacist who's dispensing these prescriptions and you are on average filling 11 per day, you're going to start noticing that this is a large quantity and it might raise a red flag for you. And pharmacists have the ability to refuse to fill a prescription if they think that there's abuse of a drug involved. And in fact, many of Walmart's pharmacists were doing this. Part of the memorandum of agreement with the DEA was that Walmart was supposed to be providing this information to the DEA so that the DEA would be able to pick up on these abusive doctors. And so it's not like Walmart didn't know what was going on, right? They had explicit internal systems in place as part of their agreement to cooperate with the feds to monitor this sort of thing. And yet, in this period under which they were covered by the agreement, they were still dispensing this many drugs. So the Eastern District of Texas, even though they started out with a case against two specific doctors, they uncovered a lot of information and became increasingly involved in this investigation that they decided to then target towards Walmart. Now, what was Walmart arguing this whole time? They claimed that this is just a ransom, right? That it was an attempt by these attorneys and prosecutors in the Eastern District of Texas to extract money from Walmart, to maybe build up some personal fame. I mean, after all, right, the government approved the sale of opioids. Opioids, as long as they were prescribed by doctors, were legal, and so was it really fair for these prosecutors to be going after Walmart? And so Walmart was essentially claiming that this is a shakedown, that they weren't really responsible for doing something that is legal.
Yeah, this is typically the attitude that most large companies use when they are attacked. They have two lines of defense. The first one, it's a rogue employee, and so they tend to dump all the responsibility on the rogue employee. Or they say this is a conspiracy against us. They generally accuse whackers of a conspiracy theory, but they are very happy to embrace conspiracy theory. This is conspiracy because we're big, we're famous, and so very aggressive U.S. attorneys want to build their reputation and their fame by going after the big companies. And there is no question that there are cases like this. It's not past me to think that some attorneys generals might exaggerate the case because of the potential benefits that they see, or because of a natural dislike for large business like many lawyers have. But what is remarkable in this case is that Joe Brown was a Trump appointee. So it's very hard to imagine that a Trump appointee has this particular vendetta against a large corporation.
So what I found really interesting about this case is that I think ProPublica did a great job of outlining all of the ways in which Walmart was able to sort of shapeshift and like move away and sneak away, and then in some cases be really aggressive towards the government and end up essentially dodging regulators. The case is still ongoing and negotiations are still ongoing, but for the most part, they have been pretty successful in evading these prosecutors in the Eastern District of Texas. So what we want to do is to outline these various strategies and also outline the benefits that are conferred to corporations by our legal system itself. So one of these comes from the top, the Attorney General's office, and actually isn't an idea that Bill Barr has put forward. It was something that was popularized by Eric Holder. This is the idea of a deferred prosecution agreement. So if regulators at the federal level want to pursue charges, either criminal, usually criminal, but sometimes civil, against a corporation, they can do so, right? They can indict that corporation, or alternatively, they can seek a deferred prosecution agreement, which is kind of like probation. It's kind of like the government saying, we're going to come after you in 3 years if you don't comply with what we want you to comply with. But look, if you're good for that 3-year period, we'll drop the charges and you don't need to worry about it.
But generally, dropping the charges comes also with some money involved so that the Attorney General can show off that they got a big fine. The CEO generally blames the previous CEO for that and charges that against the earnings, but then says, it's not my responsibility. And at the end of the day, who really pays for this are you and me, Kate, because we are shareholders through our index funds in Walmart. It's impossible not to be shareholders in Walmart if you own any index. And the return on your stock is going to be affected by the fact that they pay a big fine to the prosecutor. And so there is this kind of nice understanding between large corporation and prosecutors. They play this game At the end of the day, nobody goes to jail, nothing changes. The only thing that changes is that you and I are poor.
Not only are we poorer through our retirement holdings, but we're also made worse off if incentives aren't aligned properly, right? If managers at large companies aren't scared of ever having to go to jail or aren't scared of ever actually having to go to trial, then they're potentially going to continue the wrongdoing.
So this is known in jargon as too big to jail. In large corporations are so important, they cannot be punished. And this is, in a sense, is a backlash after the criminal prosecution of Arthur Andersen for obstruction of justice. That criminal prosecution led to the demise of Arthur Andersen, was later reverted at the Supreme Court level. And so people say it's very dangerous to attack corporations because you can create damage even before you're sure that you're right in creating this damage. And that led to an overreaction that started in the Obama years. In a sense, prosecution, white-collar prosecution dropped dramatically during the Obama years, but also continue even more under the Trump administration. And in fact, we are at the 30 years low in criminal prosecution of white-collar crime.
So what specific strategies did Walmart take to wriggle out from under the potential charges that they faced? Number one is to control the narrative. So in the very beginning, there was this memorandum of agreement between Walmart and the DEA. Walmart was supposed to send the DEA all of these records of pharmacists who refused to fill various drug orders, various prescription orders. Now, they did do that, but they didn't include all of the notes that they were supposed to, or the notes that the pharmacists put in these orders for why they were not filling them. In essence, even though Walmart had come to this agreement with the DEA, they were supposed to turn over information, but they had control over how much information they were able to turn over, and they decided not to release the full amount.
This is a bit of a game of chicken because every defendant tried to play some strategy. But if I am a small company, my favorite one is Chuck E. Cheese, and I am accused or I'm under investigation by the Department of Justice, I'm terrified to be criminally indicted for obstruction of justice. And so in the game of how close I go to the line, I'm pretty sure that I go very far from the line because for me, Chuck E. Cheese, a criminal indictment is end of my business. But if you're Walmart, especially after the Arthur Andersen case, you know you're not going to criminally indicted for obstruction of justice. And so you can push at the line, past the line. We let the sort of judges decide where is the line. But clearly, as an economist, we can say very easily that your incentives are dramatically different than the incentives of Chuck E. Cheese. You can get away with much more than Chuck E. Cheese.
So the second thing is deny, right? This isn't something that's specific to corporations. This is something that we learn like as kids when our parents get mad at us for like drawing on the wall with crayons or something. But it's a strategy that corporations also use when they're up against prosecutors. Even though Walmart did sort of shift their strategy at some point in this case, remember that there were a couple doctors who were basically like running pill mills. And originally, Walmart was hesitant to impose like basically a blacklist on these doctors. Eventually, once those doctors were being investigated, they switched their strategy and did impose this sort of blacklist or what's called a corporate block. Even though they switched their strategy, they never admitted any wrongdoing.
But like if you are a parent, at least as a parent, I had a rule that if my kids did something wrong and they immediately admitted, they were punished very lightly. If they deny and then I discover they did it, they will be punished very severely. Okay? And I think it works because my kids were pretty honest in reporting. And I think that you should have the same rule. And in practice, we do have the same rule that if you admit right away, there is some form of reduced sentencing. But if you are Walmart and you know you can basically pull this off as long as you can, you have no incentive to come forward fast and admit because you know that the other strategy works better.
And not only that, I think this is kind of where it gets tricky for a big company like Walmart. let's say they had abused their power when it came to dispensing opioids. What happens if that comes to light? Is there a single case that the United States brings against Walmart? I mean, potentially no, right? There could be individual cases brought by individual states, in this case, the Eastern District of Texas. There could be like class action lawsuits that are brought against you. There could be like civil versus criminal cases. There's all sorts of different cases that can be brought against a company like Walmart. And so if they admit wrongdoing in one case, it actually makes the potential for their like liabilities associated with that wrongdoing much larger, because then the other plaintiffs in the other cases can say, look, they already admitted the wrongdoing in that other case, and that makes their arguments easier to make. And so in some sense, the incentives are not very well aligned when it comes to our prosecutorial system.
So it's as if you had many parents and they did not agree on the strategy, and you confess to one and the other punish you brutally.
Exactly, yeah.
But of course, one of the strategy that works the best is to hire prominent attorney that are well connected with the administration. In fact, the irony is that most of the time, the attorney that large corporations hire are former US attorneys that made their name by going after large corporations and then make their money by defending large corporations. So the revolving door in the Department of Justice, on the one hand, ensures that you have talented people at the U.S. Attorney Office, even if you don't pay very much. But on the other hand, really undermine the willingness of U.S. attorneys to be too tough. They want to develop a reputation to investigate, but also not really to destroy a company. Because do you really think you're going to be hired by Walmart after you destroy another company like Walmart?
Well, actually, Walmart's own internal counsel included a former U.S. attorney for the Western District of Arkansas who actually prosecuted a Walmart insider successfully. And so in some sense, he was rewarded for taking a hard stance against Walmart, but Walmart was smart, and they knew that if they could get the best prosecutor to win a case against them, then that person would also be the best person to prevent future cases from being won against them.
And this is actually one of the important matter of disagreement in the discussion in the literature about revolving doors, because some people say that these revolving doors create the right incentives if indeed Walmart hire the toughest people that did the worst damage to Walmart as their own legal counsel. That creates very strong incentives for U.S. attorneys to go after Walmart. On the other hand, when they step down from U.S. attorney, they go and work for Walmart, that makes them more lenient to a large corporation. That's a disaster. And I fear the second hypothesis is more likely than the first, but there is a disagreement in the literature.
So in this case, Walmart has gone out and they've hired the best lawyers that money can buy, these very expensive lawyers. Then what do? The next tactic is something that we have discussed on this podcast before when we were talking about the Business Roundtable decision, right? Jamie Dimon announces, we no longer need to be so accountable to shareholders. We should be accountable to all stakeholders in the corporation. And we talked on that episode about how it's dangerous if corporations start talking about policing themselves, because then it takes the ability to police out of the hands of the government. This is also something that Walmart did. So once they were alerted of these possible charges coming from the Eastern District of Texas, they announced that they're running their own internal investigation. They were like, all right, you can stop looking at us because we're going to start investigating ourselves. And lo and behold, they found no evidence of criminal wrongdoing. And as the potential charges started to ramp up, they became more and more serious about taking their own internal steps, aimed at opioid misuse. And in fact, they even had Ivanka Trump come visit one of their facilities very publicly to announce that, Walmart is finally getting really, really serious about this. You don't need to bring any criminal charges against Walmart because we've got it all under control.
And I'm sorry if I keep using this analogy with kids, but it's not a bad strategy with kids to say you have to control yourself, basically self-regulate. But this is generally done under the shadow of a potential big punishment if you don't. And in the Walmart case, this becomes increasingly less likely, also because they really pull what I call the trump card.
The literal trump card?
The literal trump card, in the sense to adopt the Trump strategy against the prosecutorial office. What is the Trump strategy? Is to question the motive of people coming after you. So they start saying that the prosecutor were using the threat of criminal charges to extort a larger civil fine. So this is a bit like Trump started to question judge because of his Hispanic origin and say whether he was independent and was unbiased. Walmart started to question whether the U.S. Attorney Office was unbiased. And the funny thing is, if the U.S. Attorney Office was appointed by Bernie Sanders, you might think that there might be some possibility of this. But the U.S. Attorney of the Eastern District of Texas was appointed by Trump himself. So it's very hard to imagine that the Trump appointee has this big agenda to destroy Walmart.
Now, another literal Donald Trump strategy to use is to make a mistake in language and to turn it against your enemy. Example that comes to mind for me is the case of like Elizabeth Warren and, the false claim about her background. And then Trump called her Pocahontas for several months. Walmart did maybe a less intense version of this, but something similar with a statement that was made in a private meeting. And so it's, to be clear, not obvious what was said, but what the Texas prosecutors claim is that they said something along the lines of Walmart should be embarrassed for their actions. And Walmart's attorneys took this to say that the objective of the regulators, of the prosecutors, was to embarrass Walmart. And so this word embarrass sort of became twisted and convoluted, and they're still kind of arguing about it. They're still using it frequently. Because if Walmart is able to successfully say, look, we got the prosecutors to admit that they were trying to embarrass us, then that just strengthens their own claim that this is really a personal agenda on the part of the prosecutors.
And let's be honest here, I think that filling 11 prescriptions a day by a guy who has been denied by most of the other pharmacies the right to fill prescriptions. So it's not like Walmart was alone in this. Many other companies received prescription filed by Dr. Diamond. Most of them deny those prescriptions. And Walmart might keep doing it for years. If it's not embarrassing, I don't know what it is.
I mean, I should insert the claim. Walmart alleges that the government is unable to prove that any of those other pharmacies turned down those prescriptions. But according to ProPublica, they got some evidence that they were, in fact, being blocked.
The COVID-19 pandemic is a global crisis on a new scale. Listen to the new podcast, Pandemic Economics, from Stitcher and the Becker Friedman Institute for Economics to help you navigate this difficult moment. Hosted by Tess Vigeland, former host of Marketplace, and New York Times reporter Eduardo Porter, featuring insights from top economists from the University of Chicago with data-driven research on topics ranging from the impact on global financial markets to how this will change the nature of work. New episodes every Thursday. Subscribe now to Pandemic Economics.
So Walmart so far has been taking a number of defensive strategies, like controlling the narrative and denying the wrongdoing and self-regulating, that at some point started to switch over to more aggressive strategies, like, claiming bias on the part of the prosecutors, exploiting this term embarrass. At some point, they were like, all right, look, let's try and settle this. Let's offer the prosecutors a little bit of money. And so they offered $34 million to settle, which the Texas Eastern prosecutors considered basically offensive. It was an offensively small amount of money, given what they viewed was the real damage Walmart did.
And this is not the first time that Walmart get away with a small fine for a large, at least alleged crime. Because during the Obama administration, Walmart was accused of bribing people in Mexico. And there was a New York Times expose of the investigation. And the Obama officials were trying to settle for $600 million. And eventually, Walmart was able to sell for only 282, which, of course, for you and me, Kate, this seems like an enormous amount of money, but for Walmart is literally pocket change.
Yeah, so if you think about it, there's a lot of turnover in the justice system. There's a lot of turnover amongst administrations. So if, as a last resort, you as a company feel like you're going to end up having to pay some money, then you should delay as long as you humanly can to pay that money in the hopes that you end up having a more favorable administration down the road. In fact, for these anti-corruption battles, or I guess, the charges of corruption being brought originally by the Obama administration, Walmart ended up spending about $900 million in legal fees, right? That's like way more than they ended up paying in the settlement, and also way more than what the Obama administration was seeking them for. But in some sense, it's a good strategy because it prevents like future charges being brought by other administrations or by, different states. And so this tactic of like delaying and spending the money on lawyers, but not really being willing to pay out much in settlements is, in the long run, a good tactic.
And this is very important because most people, when they think about the term rent seeking by corporation, they think about lobbying or campaign contributions. But the amount of money spent in lobbying and campaign contribution pale by comparison to the amount paid to lawyers to prevent this criminal indictment or civil indictment. $900 million in 1 year or a couple of years is an order of magnitude bigger than every lobbying that Walmart has done. This is ultimately a form of rent seeking. So a huge amount of money that is wasted from a societal point of view because those lawyers are not producing something that is good for society overall, but they're just producing a smaller penalty for somebody that might have violated the law. And so that is a huge waste. Not only is it a huge waste, it's also extremely unfair because if I'm Chuck E. Cheese, number one, I don't have the resources to do it. But most importantly, I don't have the connection to do it successfully. And so if I'm Chuck E. Cheese, I have to play by the rules. If I am Walmart, I can afford not to.
So this connections point is kind of where things end up. Even though Walmart was willing to settle for a certain amount of money that was under negotiation, it ended up pissing off the lawyers in the Eastern District of Texas, and so they continued to pursue these charges. So finally, as like the last straw, Walmart called in its favors and called the people that they knew in Washington. So what they did was that they had their Jones Day lawyer. Jones Day is like a big white shoe legal firm, which, for the sake of full disclosure, I have worked for before, but only in like a very minor capacity.
Wow. You are involved in the case, Kate.
No, I was a teaching assistant there, and I got paid a total of $3,000 over the course of like several years of being a teaching assistant. I think that's what like one of their lawyers would probably bill Walmart for maybe 45 minutes. And so it was a tiny sum of money. I have no allegiances to Jones Day. But anyway, they're very well connected. And so Walmart's Jones Day lawyer sent a letter to the Assistant Attorney General, who was also head of the Department of Justice's Criminal Division. And then soon after, lo and behold, the DOJ allegedly ordered Texas Eastern to stand down, and then a couple months later told Walmart that they wouldn't prosecute the company.
So at the end of the day, it looks like my Italia conspiracy theory is correct. U.S. attorneys are appointed by the president. Certainly, the U.S. Attorney General is appointed by the president, and the president decides what he, most of the time, actually all the time so far has been he wants to do. This creates perverse incentives because, number one, creates perverse incentive of large corporation to be friend with the president so that they can get away with literally murder. That's the connection between market power and political power that I'm very concerned about.
I mean, I think the connections are one part of the story, but not the full story. There's a lot of perverse incentives here, right? There's perverse incentives to delay the case as long as possible. There's perverse incentives to, like, never admit any wrongdoing because of the potential legal liabilities down the road. There's perverse incentives to switch strategies based on like where they are in the case. There's perverse incentives to keep all of this out of the public eye so that nobody ever knows what's going on. And so the connections are part of it, but not everything.
I agree with you that is not the entire thing. However, as my repeated example of the parents suggests, if you operate under the shadow of a possibility of a big penalty, I think all these tactics might be reduced. If you know by experience, and this is why it's a learning by doing, because corporations try and they see they can get away, and then they double the ante. If you eventually get punished big time, then you're more careful. But think, this is not just a US problem. Volkswagen had a defeat device to actually hide the performance of its diesel car and the pollution of its diesel car from the regulators. And yes, one guy from Volkswagen had been arrested in the United States because he was so stupid to actually go through Miami in a trip. But otherwise, nobody went to jail, and Volkswagen will pay or had paid some fines, but nothing really has changed. The problem is more corporations are watching and learning. And so the secret is, if I am too big to jail, I can get away with murder. So, Kate, is this a capital is or capital isn't?
I think this one's pretty obvious. Walmart being, let's say, I'm not using the legal term here, I'm just using my own word, somewhat negligent in dispensing opioids, which ultimately killed some people. That's obviously capitalism, and their ability to get away with this, their ability to use their connections and their power of the legal system to get away with it, that's obviously a capitalism. Now, I think another part of this, which is less clear to me about, like, what's the right solution, how do we manage this, is a coordination issue on the part of the government, right? Between the states, between the federal government, even between, like, different governments, right? Between the US, between the EU. When we have huge multinational corporations, which are, as you've said, Luigi, too big to jail, how do we come up with a coordinated system to make sure that they face the right punishments and they face a coordinated set of regulators? This is a really difficult issue that I don't know the answer to.
Yeah, you're absolutely right, Kate. Late political economist Alan Meltzer was saying that capitalism without bankruptcy is like religion without sin. It doesn't work. And I think that this doesn't only apply to bankruptcy, it applies to punishment. I think that in order to have a good capitalist system, we need to have some rules in place, and these rules need to be respected. And we might disagree on how many rules should be in place, but I think we should all agree that the rules that are in place should be respected. Because if we start to develop a system in which some rules are not followed, and particularly bigger players can play by a different set of rules because they can not follow certain rules and get away with that, like by contrast, if you're a small company, then you have to follow all the rules, then we even distort the competitive game. And so this is all a destruction of the spirit of capitalism, where everybody is on equal footing. And many people say, oh, we should punish large corporations because they became large because they are efficient. And I turn this upside down and I say, maybe they turn large because they know that by being large, they can get away with murder. And so they're not more efficient, they're actually creating more negative externalities. And so they make more money, but at the cost of all of us, at the cost of drug prescription being filled and people dying of those prescriptions because the proper compliance system were not in place.
Capital Isn't is a podcast from the University of Chicago Stiegler Center in collaboration with the Chicago Booth Review. Also check out promarket.org, a publication of the Stiegler Center. Don't forget to subscribe and leave a review to Capital Isn't wherever you get your podcasts.